Whenever a controversial police shooting happens in Bihar, the political theater begins almost instantly. Politicians rush to the scene, hand a grieving family 10,000 rupees, and give their quotes to a flash of cameras. It operates on a predictable schedule. The politicians get their media coverage, and then they wait. 15 days later, when the news cycle moves on, those same leaders stop answering the family's phone calls. To manage public outrage, the government announces disciplinary action. But suspension usually hits a handful of low-level constables who had nothing to do with planning the operation. In the Bharat Tewari case, despite the massive public spectacle and media coverage, an actual first information report, the most basic legal requirement for an investigation, hasn't been filed. Focusing the public's attention on suspended street cops masks the systemic rot higher up the chain. When the state finally announces a judicial investigation, they often bypass active sitting judges in favor of a retired one. Even more critical is the terms of reference, the legal framework that defines what a judge is allowed to investigate. If this document is left empty, the probe has no actual power. Leaving that document blank is a strategic choice. Without explicit legal boundaries, top-tier political figures are shielded by default. A high-profile probe with no boundaries and no official FIR is an administrative maneuver designed to limit liability, not find the truth. To find out how an extrajudicial killing is greenlit, we have to look past the officer holding the gun and examine the middle management of the justice system. Someone signed the paperwork. Yet there is no scrutiny of the magistrate who authorized the encounter, or the special task force chief who deployed the unit. The same immunity shields district leadership. The superintendent and deputy superintendent control operations, yet neither faces a routine transfer. The constable who fires the weapon is the executioner of a tactical blueprint drafted by a chain of command that remains completely untouched. That blueprint traces back to the top of the state hierarchy, specifically the office of the Home Minister. A Home Minister calling for criminals to be shot based on their caste or identity translates into a lethal mandate for law enforcement. Normalizing violence from the top signals to officers on the street that non-judicial executions are now state-approved policy. There is clear legal precedent for top-level accountability. In Gujarat, Amit Shah faced trial and was jailed over his alleged role in fake encounters while serving as Minister of State for Home Affairs. Inflammatory rhetoric from political leaders cultivates a police state where the gun replaces the courtroom. Politicians justify these encounters by claiming they are delineating dangerous criminals to protect the public. But under the Constitution, the power to determine who is a criminal belongs strictly to the courts. It is not the choice of a minister, an MLA, or a police officer. In this system, punishment is dispensed on the spot, via a bulldozer or a bullet, based on identity rather than evidence. This arbitrary violence contrasts with India's history of the rule of law. Even Nathuram Godse, who assassinated Mahatma Gandhi in public, was granted a full legal trial. The same legal process applied to the assassins of Prime Minister Indira Gandhi. They faced a judge, not a street-level execution. Even Ajmal Kasab, captured with undeniable evidence of his terrorism, went through an extensive judicial trial because the law dictates a process for everyone. A democracy cannot survive if it only punishes the hand that pulls the trigger while refusing to investigate the minds that aimed the weapon.